I had hoped that we could find a way to get to the real point of hearing from her, perhaps by offering her her immunity through some kind of negotiations with her counsel, since that is what we all want. Voting to waive her constitutional rights must be the very last resort. With all respect, Mr. Chairman, I do not believe we're at that point yet.
Would the gentlelady yield?
Although we may well get to that point.
I'm going to be not supporting your amendment, but what I wanted to make clear was all the things you said, including trying to get her to give testimony, the possibility of limited immunity and so on, all of that by definition comes after Mr. Gowdy's assertion during the earlier hearing that she had waived. Ultimately, as I said earlier, and I think you were here for it, we're dealing with a motion that originated from Mr. Gowdy that she had waived, a decision that I reserved for 37 days. And
Mr. Chairman, I don't understand. Are you saying that since she waived, we don't need to discuss whether perhaps she would testify if given immunity?
No, her counsel, the decision of whether she waived and the decision of whether or not they would proffer and all those other decisions, quite frankly, are not going to happen until after we conclude her testimony, which she began, continued, and then stopped earlier. She is still a witness pending from a recessed hearing. And that's really what we're doing today, is preparing to go forward with the hearing.
Mr. Chairman, have you considered offering her immunity? May I ask, have you considered offering her immunity so that we may discover the very evidence we seek from her?
Madam, I apologize, but there are some things that cannot be said in an open hearing.
And yet we're supposed to vote now to waive her constitutional, that she has waived her constitutional rights. That is a very serious burden to put on us without more information, Mr. Chairman.
I appreciate, but Madam, we were all here or eligible to be here. We have noticed this markup pursuant to the committee rules. The gentlelady had 37 days in which to seek counsel. 37
days you noticed this hearing?
37 days in which to seek counsel as to a question of a statement made.
When did you notice this hearing, Mr. Chairman?
The gentlelady's time has expired. I will now recognize the gentleman from South Carolina.
Thank you, Mr. Chairman. First blush,